Hey, it's Navy Dowdy here in the Chicago area in the great Midwest and the fabulous United States. This week we're going to talk about kind of a niche tax idea for you, and it's really about recent conservation easement tax cases. And I want to talk about this because they're settling favorably for the taxpayer. Now, let me say, first of all, the last thing we want is any of our clients to be involved in tax court cases. However, here's a recent headline in the Tax Analysts, and it reads, "Reasonable IRS appraisal triggers conservation easement settlement." The article describes a long battle involving what the IRS calls syndicated conservation easement transactions. Hale E. Shepard, Esquire, an Atlanta, Georgia-based attorney, stated in review of the ruling that after the IRS was unable to win the case on technical issues by filing a motion of summary judgment, after the partnership provided proof that any post-donation improvements would not materially change the value, and after the partnership submitted a qualified offer, the IRS agreed to settle the case before a tax court trial, allowing the partnership to claim 85% of the original tax deduction. It's interesting to note that the IRS was insistent that any settlement include language that they were not responsible for taxpayer legal fees, which could provide insight into concerns for this mountain of cases and the potential to be held liable for legal costs of those who were falsely denied due process and others who had properly followed tax court rules. Another article about another recent case, and this is case USCA 11 case 20-13700, filed on 12/21 or 12/29 of 21, David and Tammy Hewitt versus the IRS, in a tax court appeal, also had a good outcome for the people. This outcome helps to show that the IRS has been trying to go after the syndicated conservation easement industry on a case-by-case basis, using strong-arm tactics and technical issues instead of simply working with the industry to create a set of blue-sky rules, much like what was done with charitable planning industry, and then moving on to other cases of the tax code that they do not like. We can only hope that this shows it is time for that approach to be discontinued. And this is important because this is one of the ways that you are able to get some tax deductions based on charitable land contribution easements. So you don't have to have the land yourself. You can invest in a group of syndicated easements that will give you some tax deductions. One of the few ways that people can get these types of deductions if you are mainly a W-2 wage tax earner. So again, we don't want our clients to be in tax court. However, the IRS does appear to be softening their stance on conservation easements. And I should say that Congress has always liked conservation easements because they keep re-upping the law that allows for them, whereas the IRS doesn't like them. So that's enough for this week. A little bit technical. However, just remember, financial fitness can be beneficial to your wealth.